Welcome, everybody, to today's webinar. As always, we want to remind you that this is an informational webinar and it is not to be construed as legal advice. It's important that you realize that our speaker is an expert, but please, again, this information is provided for your learning and, again, not to be construed as legal advice. We're going to be talking about children and minors in the library. This is a policy area of great interest, and our legal expert, Kris Goss, who is also the director of the Library Learning Hub. Let's see if I can get that correct this time, at Helena College. Kris serves as an attorney, and he works with the firm of Jackson, Murdo, and Grant in Helena. He also in the past has worked with the School Boards Association, served as a law clerk in the chambers of the Honorable Sam E. Haddon in the United States District Court for the District of Montana. And Kris brings his background in education policy and that rich history as an attorney, as well as now a library director. And we're so grateful that he's able to join us and to give some really clear information and share the ideas that I think will help all of us to craft and examine the policies that we have around these topics. So with that, Kris, I would like to invite you to share your screen and take it away.
Thank you. It's great to be back with you to discuss this important topic. As Chloe said, it's one that's on our minds all the time. And one of some of my first duties here at Helena College were related to adjusting our policy related to children in the library so that students who are working with the tutor in the library or visiting a student group in the library made sure that they understood that the library is here for their children as well. As a public library serving the Helena community, this is a library that's open to the public, and we want to make sure that children are welcome and that our children's collection is accessed and that children benefit from being present in a library. The knowledge, the familiarity, the benefits that come with being present in a library at an early age is something that we all, as library professionals, seek to emphasize. And what better way to do it than making sure that you establish a welcoming library setting for children, and also making sure that parents are comfortable in having their children in the library. And that's where this topic came from. When Colette and I were building an agenda for the summer and fall trainings, how do we talk about this? And once we identified it as a possible point of discussion, it caused me to think about not just the children's presence in the library and serving children in the library setting, but the related issues that come with that in accordance with Montana law. And so those are our outcomes today, is making sure that everyone has that operational knowledge. As Chloe said, this is not legal advice. It's something that's designed to help you build the foundation of knowledge to ask the right questions when these issues come up, or be reassured that the work that you're doing is on the right track, or if there's a small area that needs some clarification, we're able to assist with that as well, and we'll provide some contact information to help get you advice on specific situations that you might need. So we start at the beginning of, as always, what are the laws that address children in the library? And it's funny, but this is something that is familiar to all of you that have been observing and watching our sessions throughout the summer. We always start with the First Amendment, because the First Amendment establishes that right to access information, and making sure that we recognize the right of children, the right of minors to access information is foundational to our work as librarians, in making sure that each person, each patron that comes into the library has that right to access information. And that's That's where we start. We start with the First Amendment to the U.S. Constitution and Article 2, Section 7, the Declaration of Rights in the Montana Constitution, that freedom of speech that extends to the access of information is available to each Montanan that visits one of our libraries. And with that in mind, we know that it's going to set the tone for the rest of our discussions. And if you think back to one of our early sessions, we know that the Montana Constitution extends those rights not just to people who have reached the age of majority, not just adults, but people who are not adults. And that means that each Montanan has the right to access information, the right of speech, the right of expression, the right to receive information consistent with Article 2, Section 15 of the Montana Constitution. Unless there's something specific in law or something specific in the Constitution that says otherwise, the fundamental rights that are guaranteed to each Montanan through our Constitution extend to those that are under the age of 18. And that's profound in that it makes sure that each of your patrons who are not yet 18 or our children have those rights. And by extension, they also have a right to privacy as minors in Montana, which is going to play a role in some other aspects of library services related to confidential information. But we include these provisions to reassure each of you as librarians that the right of access to information, the right of speech, the right of lack of government interference in those two fundamental rights, as detailed in the U.S. Constitution by extension through the Montana Constitution, apply to each of our child patrons, those patrons that are minors, teens within the library setting or receiving library services or attending library programs. So we then look to some of the new laws that have emerged on this topic and how they interact with existing library laws. And many of you are familiar with the parental engagement laws that have been passed the last 2 sessions ago and then clarified in this most recent session as codified in 40-6701, Title 40 related to families and parents, minors, the relationship between parents and their children, and the rights or the obligations of government to engage with parents. And so this statute, as we talked about a couple of different sessions, outlines the fundamental parental rights exclusively reserved to the parent of a child without obstruction or interference by a government entity, include the authority, the right to direct the upbringing of the child. This is codified now in Montana law. It's been interpreted by federal courts through the 14th Amendment to the U.S. Constitution. The rights of due process extend to the right of parents to direct the upbringing of their child, to raise their child in a manner that they determine to be appropriate. So what that means, though, is for a library as a government entity to ensure that they're collaborating with parents, engaging with parents, and ensuring that the rights of those parents are honored through the operations of the library, and when honoring the child's right to access information in the library setting. And it requires a balance between the obligation of the library to deliver services to patrons, as well as the rights of that individual minor patron and the rights of parents to raise their child. And all of that is going to play a role in how the library develops its policies. And so when you look at 40-6701 subsection 3, employee of a government entity may not encourage or coerce a child to withhold information from a child's parent, may not withhold from a child's parent information as relevant to the physical, emotional, or mental health of a child. So those provisions in that parental engagement law are something that librarians have been doing for years. Now we know it's codified in the statute. We know that obligation exists and how it interacts with library laws and how it interacts with the rights of patrons who are under the age of 18 are going to be set forth in the library's policy. So section 22-1309, something that many of you are familiar with, the Board of Trustees having exclusive control over the expenditure of the public library fund, the construction and lease of buildings, the operation and care of the library, and specifically the authority of the Board of Trustees of the library to adopt bylaws and rules for the transaction of business and for the government of the library and its operations. So you know that that authority exists. The legislature has codified that authority of the library board to develop policies to that end. So if you think back, we know that the patrons in the library setting have that right to access information consistent with their rights under the U.S. Constitution as American citizens, as residents and citizens of the state of Montana, similar rights. Those rights extend to those that are under the age of 18. Those rights of privacy extend to those that are under the age of 18. But parents of those people under the age of 18 have rights as well under both Montana law and the interpretations of the U.S. Constitution. And so balancing those two sets of rights will be the obligation of the library board through the development of its policies. As part of that process, we have the expectation of the Library Records Confidentiality Act. And no person will release or disclose library records or a portion of library record to any person except in response to the procedures and forms giving consent as determined by the library. And so this provision in 22-1-1103 specifically refers back to the authority of the library board in 22-1-309 to set forth the process by which there will be potential disclosure of library records. And disclosure of library records would be consistent then with 40-6-701, consistent with the policy adopted by the library, as well as the rights of privacy set forth in the Constitution for those that are under the age of 18. So you can see it starts to get a little tangled, but the library board has that authority to set forth how this is all going to work. And we'll talk about how that can work in a manner consistent with the authority of the library board, the rights of the patrons under the age of 18, the rights of parents, through the adoption of a clear and consistently enforced policy. The other times that the disclosure of library records may occur is, of course, if there's a court order or if there's the disclosure for the purposes related to overdue stolen materials and making sure that that occurs in a manner consistent with the policy. So that's for public libraries. For those of you that might be joining who work as a school librarian, that applicability of that Library Records Confidentiality Act is going to be a bit different because of FERPA, because of your obligations as an educator in a K through 12 setting, and the obligations under FERPA for collaboration with parents, the Pupil Rights Act, another set of federal laws that are codified most likely in your school district's policy. It's going to look a bit different, and the interpretation and application of those federal laws, the parental engagement laws in Title 40 as they apply specifically to schools in 40-6703, is going to make the Library Records Confidentiality Act operate a bit differently. And so your school district policy will govern, and you'll have a cross-reference from your FERPA policy in the school district to your library records policy, and that should be something that you can raise with the principal or the district administrator to ensure that you have that consistency between the applicable federal laws specific to school libraries and the rights of parents and how that interacts with the rights of the students as well. So just that the caveat is important to remember. For public libraries, we've talked about the interaction between the rights of the patrons as they exist under the First Amendment and Article 2, Section 7 of the U.S. or the state Constitution, how that interacts with their rights of privacy as a citizen of the state of Montana. That also plays a role in the responsibilities of the board of the library and the staff in the library. We know that the board and the staff have that obligation with regard to parental rights and how that all interacts through the applicable policy adopted by the board. The other aspect of this to keep in mind is just the mere presence of the minor or the child on the library's property. That most likely is what you were expecting to talk about today. We have to talk about the other operational issues as it relates to children, but the safety and the welcoming setting that is expected for anyone who's visiting the library, most importantly, our most vulnerable population, which includes children. How do we make sure that that library setting is welcoming and safe? And so that comes back again to the obligation of the board under 22-1309 to have exclusive control of the construction and lease and operation and care of the library. That statute sets forth the obligations to make sure the library is in a workable and functioning and safe process and operational capacity. Similar process applies to the public library district. Those public libraries that are established through a district and governed by a district board, 22-1707 lays out those similar obligations. So that creates legal and ethical responsibilities for the library board and its employees, the library as a distinct governmental entity, to follow the laws governing library operations. It also establishes the ethical obligations for public funds to be utilized for purposes specified in the law and consistent with the library's mission. When that all is put together, what you have is an obligation to not engage in negligent conduct, to not engage in official misconduct that could be interpreted as a potential violation of the state's criminal code. But you have that duty of care to each patron and to all patrons, the duty of trust to the taxpayers and to the residents of the community who are potential patrons, making sure that the library setting is safe, making sure that the equipment, that the materials, that the infrastructure is in a workable and appropriately located setting to ensure that people are not faced with potential injury. And that includes anticipating the presence of children or vulnerable populations present in the library, and how we monitor the space to help avoid those types of potential injuries and the exposure to that type of harm. And that's the ethical obligation that comes through these two statutes, that comes as part of the oath of office that library trustees complete, as well as the employment contracts that library staff complete. All of that binds those employees, those board members, into compliance with state law, honoring the duty of care and the duty of trust that exists to and applies to each member of the library staff and the library board. So when you have those standards in place and you understand the obligation to provide a safe and appropriate setting, it comes with the understanding that the library will establish the procedures, the policies, the operational standards for the staff to complete and for the board to undertake in guiding the staff. There are possibilities for staff to be immune from suit in an individual capacity because of specific laws or the development of policies authorizing staff action in certain cases. It's important for those policies to be consistent with the laws and to not authorize illegal conduct or conduct that creates potential harm for the patrons visiting the library. It's important when developing all of these policies, these procedures, and then training the staff on these topics to involve the districts or the locality's insurance carrier, and making sure they're honoring not just the statutes, the policies adopted by the library board, any specific regulations that apply to library governments, but the operations of the municipality or county or both through their insurance carrier, and the training that they have to review infrastructure, review operations, and ensure compliance with the policy expectations for the insurance coverage, the insurance policy, but also any best practices that are established by the insurance carrier to make sure that you have that setting. And that's the first step in anticipating the presence of children at the libraries, at the library, on the library's property, or receiving library programming, is that you have reviewed it to honor the obligation and the duty of care to provide that setting that is safe, for those populations to utilize. And so when we look at the obligations with regard to interacting with parents, honoring parents' rights, honoring the rights of children to access information, all of that comes back to establishing a setting where those rights can be utilized, can be accessed. People are welcome in the library. They can know that the library is a safe setting. They know that they're going to be free from obvious harm when they come into the library setting. The shelves are attached. They're put together correctly. There's not sharp corners. There's not things dangling or hanging that might injure someone. All of that ensures that right to access information is honored in the foundational manner that the law and the Constitution expect. So how does this all apply to library operations? And what you've become familiar with through the last few weeks is development of policy to set forth how the library is going to honor the rights of children to access information, honor the rights of parents with regard to their authority to raise their own children, and the obligation of the library to establish a safe and appropriate setting for those rights to be utilized. And so we talk about sound policies and the authority of the library to set forth that policy in a way that's consistent with the law as required by 22-1-309. And so when governing children and families, minors present in the library, it has to always support the mission of the library. That mission of the library is set forth in the strategic plan or otherwise adopted by the board, is going to be that foundational statement that you will build upon when looking to update your policies or ensure compliance with established practices through the statute authorizing that policy. Then always balancing, protecting the rights of those patrons, both the rights of the minor patrons to access information in a confidential way, while preserving a safe and welcoming facility, as well as honoring the rights of parents to raise their own child. Making sure that they have transparent operations, that those patron conduct policies, the recording policies that we talked about last time, with regard to recording minors, recording individuals present in the library by staff or by others, referring to the patron conduct policies with regard to parental rights, and how that all works together to ensure that the policies are consistent with one another. We know that the parental rights policies authorize access to information. We know that they authorize parents to work with government entities on the upbringing of their child. We know that they have set forth specific examples of when their child can be recorded. And that comes back to the right of that child in the library setting to access information in a safe manner. You're also going to make sure that any conduct and behavior restrictions that apply to those that are present in the library, including those minor children or their parents, are going to tie back to the mission of the library. Because as we reviewed in the First Amendment, the fact that the library is a designated public forum, you have that situation where in order for access to information to be restricted, that has to be consistent with the rights of the individual through a strict scrutiny standard. There has to be a compelling government interest, and that government interest is going to be examined through the lens of the mission of the library. Then looking to ensure compliance with applicable criminal laws, that there isn't any destruction of property, interference with government operations, and non-discrimination laws. We're not limiting access to government services because of family status, or because there's children with an adult, or because there may be membership in a protected class other than family status. And so All of that compliance is necessary to, again, preserve the rights to access information under the laws of the United States. And then honor the rights of parents with regard to their ability to and authority, right to raise their child, but then the responsibilities that come with that. That the responsibility still rests with the parent to raise the child when present at the library, which we'll talk about how to codify that in a policy to establish that true partnership between the library as a government entity and the parents who are bringing their children to the library. Always, consistent enforcement of a policy is critical, and it will make sure then that the staff are protected in the event that there is a challenge or there is a threat of litigation, that someone says you didn't follow the law. The library can point to the policy that authorizes specific staff action consistent with the role of the library, the mission of the library, and the authority of the board to adopt and enforce those policies as set forth in statute. So when you have all of that put together, we know that we're building forward what the policy should entail, what the policy should contain. When that's put together, always start with the mission of the library. And you're familiar with the last few sessions, the sample example mission that we have for our imaginary library, the Mosaic Public Library, serves each member of the community in a welcoming and secure setting as they pursue personal lifelong learning goals. The fundamental focus of the library in this situation is those three components: accessing information, obligation to operate the library that falls to the staff, and an obligation for a safe and welcoming library setting. That's what it comes down to, in making sure that any patron who wants to utilize the library is able to do so consistent with that mission. And from that mission, we're capturing all of those aspects of the law that relate to the First Amendment right to access information, the First Amendment right to access information in a responsible way, the application of that right to access information to any patron, the Constitution of the Constitution of the United States with regard to freedom of speech, but the constitutional provision in Montana for lifelong learning. All of that's embedded there, and you can use that as a library or a similar mission to build policy from there, consistent with the obligations of the library. And so you're always making reference to the role of the staff in managing that library space, developing the collection, identifying, in this case, specific children's collection areas or areas where children can explore or use their imagination or utilize equipment or tools or toys that are available for them and their parents and their families to explore and learn about what the library has to offer. It always has the staff's role in directing individuals, redirecting individuals to comply with policy consistent with their role in the library setting. Then detailing the obligations of the parents, caregivers, or guardians. Those are the three terms that I've identified as capturing any responsible adult for someone who may be bringing children to the library. There may be other terms that you're familiar with, and you can exchange those as necessary. But to capture the obligation and the desire of the library to build the community through the engagement with families. And that's our goal, is making sure that those families have a place where those children can explore and become familiar with library services, and to that end, generate support for the library in times of questioning of the library's presence in the community. You have people who are supportive because they know how the library works with families, supports families, consistent with its mission. And then working to enforce the policy in a way that is consistent with the law to bring about fulfillment of that mission. And so when a patron is present in the library, they're subject to that patron conduct policy we talked about a couple weeks ago, and the staff then is authorized to take the necessary steps to uphold the mission by redirecting someone who is potentially in violation of that policy. So we know that what the policy, the foundation of the policy, consistent with the law, we know what components it has to hold. And so here is some sample language, potential concepts for what a children and minors in the library policy could look like. And we start with, again, that mission would be at the top of the policy, and then the library establishing those methods for patrons of all ages to visit and utilize the library, its collections, services, programs, honoring the mission, and setting forth the expectations for the patrons to utilize it in a way consistent with staff directives to protect the library's property, facilities, and equipment. Then we get into some of the details with regard to how children may be present in the library. Library staff are not responsible for the routine supervision, transportation, or care of children and minors present on library property. It simply is not the place. It's not a repository for children to go during the day and have the library staff expected to monitor them or care for them. However, as noted in state law, if a local government employee takes action as a result of an emergency that's authorized by policy, then there may be immunity for that staff member based on the actions they've taken consistent with the policy or their job description. So we have a provision through that policy that says if there is an emergency, if a child or a minor is experiencing an illness, an episode, or other type of emergency, then staff are authorized to administer or assist care when necessary if that child or minor is, in the eyes of the staff member, suffering from some type of emergency or potential harm. And then that obligation is in place by virtue of the library's authority in statute to adopt a policy. It also then allows the staff to make a decision to provide first aid, provide care, or contact first responders if there is a child present and the parents are somehow not present or not available, and you're able to do that. That might be more of a case for a teenager based on how we have this sample policy written, as you'll see in the next slide. But it's important for that provision to be there so that staff are not subject to suit because they took action without the parents' written consent, or they took action that was something that the parents disagreed with. And so a provision along those lines is important. Working with your county attorney, city attorney, or your library's attorney to help put that together to protect the staff so that they're not worried about potential liability, which freezes them and prevents action in the case of an emergency, which could result in exacerbation of the potential harm. And so that's what we're trying to avoid with that type of provision. Some libraries will look to a specific age in what is considered a child who has to be supervised by the library or supervised by the parent while in the library. When examining that and looking at it as I do here at Helena College, I don't know the age of a child. I know how old my kids are, but I wouldn't suspect to know how old every kid is. And so do I know they're 8? Do I know they're 9? Do I know they're 13 or 14? Every kid is going to be different. And so what I tried to do with this sample language is, rather than say every child who appears to be age 9 or under, every child who appears to be age 10 or over, is to say children and minors must be under the direct supervision of a parent, caregiver, or guardian while present on the library if the child or minor is unable to safely utilize the library, its collections, programs, and services without disrupting other patrons, or otherwise interfering with library operations. That puts the responsibility of determination not on the calculation of age, but instead on if someone is just not able to handle themselves. If that child is tall for their age, but they're not, they don't have the maturity to match their height. That's not up to the librarian to say, well, do you have an ID? Which they obviously don't. They're not of driving age. They don't have an ID. We don't know how old they are. But if they're clearly disrupting the library setting, or they're interfering with the programming, or they're unable to safely utilize the library, even though they may be taller or larger, bigger in stature, they may look 15, but they're actually 9. It happens. But if they can't handle themselves, then they need to be under the supervision of the parent. And that's a way to calculate it, or to develop the policy without requiring a calculation of age. Unattended children determined by library staff to be unable to safely utilize the library shall be redirected to the child's parent. Parent, caregiver, or guardian is not present on the property. Library staff is authorized to contact appropriate authorities. Again, giving the staff the authority to make the decision based on the circumstances. And if those authorities include the parent, if you're in a town where everyone knows each other, which many of our towns are, you call the parent, say, where are you? What's going on? If you don't know the student, you don't know the child, how do we contact authorities who might be able to locate them? Who those authorities are based on the resources available in the community. And all of that can be taken into account depending on the specific situation. And then some definitions. It's important to note what unattended means. The process that we took in the library here at the college is to state that unattended, it means not within the sight or vocal control of the child's parent, caregiver, or guardian. That's a way to approach it. To say you have to be able to see your kid, you have to be able to call out their name and be able to them respond. Again, that's a way to make that determination as to whether someone is upstairs to the library, their kid is downstairs, and the child is creating quite a commotion. The parent is upstairs looking at the fiction collection and not able to control their child. Is that an unattended child? It is. That child would be redirected to their parent upstairs. If the parent has left the facility, then the potential for contacting appropriate authorities. Then the definition of a child is something that is also important. Is a child, getting back to age, under the age of 14? Are they a minor? And if they're under the age of 18, I think finding that line for the staff is important, because it's going to play a role in another part of library operations, which we'll talk about in the next slide. But it also then allows the policy to capture those that are teenagers who may not need their parents' supervision, who may be able to utilize the library safely without interfering with library operations, but not creating an obligation for the library staff to supervise, transport, or otherwise care for them in case of unless in case of an emergency. So the policy can create that distinction between a child and a minor to capture your teen services versus children's services, and how the library staff reacts to those different populations, while recognizing that each of those students, children, minors, still have rights to access information in the library as set forth in the Montana and U.S. constitutions. Some additional items to think about: damage to the library property resulting from use of the library by a child or minor, invoice to the responsible parent, caregiver, or guardian. Parents, caregivers, and guardians assume the risk associated with the child or minor's presence in the library. Injuries sustained will be assigned to the parent, guardian, consistent with the definition of comparative negligence in Montana law. The child's or minor's use of the library has to comply with the conduct and behavior policies, will not interfere or disrupt the library's operation, be consistent with all library directives. Again, reasserting the authority of the library staff to make those decisions, but also applying the other aspects of the library's policy manual to this particular situation. And then an important provision that you've seen included in all of these examples, that the director or designated employee is authorized to interpret and implement the policy, including the authority to resolve grievances or complaints when the implementation of the policy is necessary. So some of that standard language that reasserts that you're using the library consistent with your rights, but you have to do so consistent with the responsibilities of a patron set forth in our policies. The staff have the authority to govern the library, manage the library, implement this policy. And if you're outside the scope of the policy, then you can be redirected. As I mentioned, with regard to the difference between children and teens and minors, it's going to come back to the process you've established for issuance of a library card. And this goes all the way back to the issue of parental engagement, the rights of parents with regard to a government entity to raise their child, how that interacts with the rights of minors with regard to their library records. And so setting a policy for development of a process for issuance of a library card, as the board has the authority to do under 22-1309, that's going to be where that age of a patron who is a minor but not a child is going to play a role. Many libraries work on this issue. They have different forms of library cards. Some may have children's card that is developed in consultation with the parents. Some may have family cards where the family has one account. They've developed different procedures for all this to occur, but there are going to be situations where the rights of the parents interact with the rights of the minor under state and federal law, and that's where the policy is going to come into effect. Drafting it in a way that is consistent with how you define a minor versus a child, or a teen versus a child, and then having that process for a teen to secure their own card separate from their family's account is going to be important. That's a discussion that's going to depend on the board's perspective, the procedures that the library has established, the expectations of the community, and how all of that is going to work consistent with the rights of parents under the law. Because if you remember the provision in the statute, it states that the library staff, as staff employees of a government entity, shall not coerce or otherwise encourage a minor to withhold information. And so making sure parents have that understanding of the process. And if a minor who has a right to access information under the First Amendment seeks advice from the library staff, that the library staff are trained in how to respond to those questions. That I can't encourage you or advise you in any particular way. I can issue you a card consistent with our policy. If you have concerns or questions, you can contact your parents. We're happy to talk to them. Standard advice and perspective to honor the rights of the parents while honoring the rights of the minor with regard to their access to information. And if that sounds like a fine line, a tricky process, it is going to be. It probably won't be for the bulk of many situations, but there's that one situation where that will require some careful implementation of the policy to honor. They're not competing sets of rights, but honor and balance the two sets of rights that exist in this situation, and to make sure that libraries are not just complying with the law, but they're actively engaging with parents, but the libraries are also honoring the right of access to information that minors may hold, as well as the Library Records Confidentiality Act. The age of that library card holder and how and when the parents are involved with it is going to determine how there may be access to the records. It may determine the applicability of the patron conduct policy with regard to minors in the library. It's also going to play a role in how parents may be expected to pay for damaged or lost materials if the card has been issued without the parents' participation. You have a 17-year-old come into the library, they get a card consistent with the library's policy. Does that then create a situation where the parent has the right to know the information about the records? Yes, there is an exception in the library records policy where they would have access to that information as it relates to the retrieval of payment for lost or damaged materials. But does that then open the door for the parent to review other materials that may not have been lost or damaged? And that's where the development of policy and the engagement of the parents, and how those two sets of statutes work within one another to meet both sets of rights, the right of the minor to access information, the right of the parents to raise their child without interference from the library. So if we return to the mission of the library, our imaginary library, Mosaic Public Library, you have that obligation to set forth for personal lifelong learning goals, safe and welcoming setting consistent with the applicable laws. Does that create a sufficient government interest to adopt a policy? That's something that hasn't been litigated. It's not something that's been reviewed by the courts of Montana yet, given the recency of the parental engagement laws, but it's something that you are going to anticipate to take into account when developing that library card policy, and then making sure it cross references to the distinction between a child and a minor when present in the library. All of those are then outlined in the next set of bullet points. And one item to keep in mind for those that are working in academic libraries, like I am here at Helena College, if you have dual enrollment students, or you have that obligation to serve the public, and you have community patron cards that are issued, having that understanding of the parental engagement laws, the rights of parents to work with government entities on the upbringing of their child, and the obligation of the government entity to work with the parent on the upbringing of the child. Having policies in place for those minors who are community patrons, or the dual enrollment students who are accessing library services as college students but are still enrolled in high school, all of that has to be taken into account. And if any of the academic librarians are on the call, something we've worked through here at Helena College, and would be happy to talk more about it. It's something to be mindful of as you consider all of those issues. So we'll take some time for questions. Just want to remind everyone about Montana Library Assistance Helpline, something that we put together with the Library Association. We've had great questions come through the helpline since we launched it earlier this year, and we'll continue to monitor and help in anything that comes up with any of those library assistance and operational issues that may emerge. And we'll be having a session at the Montana Library Association fall retreat on the 5th of October, discussing how the helpline has been working, and what I'm calling the helpline's greatest hits. Some questions that have come in that'll be de-identified to just help remind everyone what type of questions we're handling and what type of issues have come up in libraries around the state. So watch for that this fall. Nicole, have there been any questions come in? I've seen the chat pop up quite a bit. Is that
Yeah.
questions that have come in?
Just there are a couple of questions I've asked folks to respond with language from their own policies, just so that we can include kind of the range of options with our participants today. But there is one question that I think is worth thinking about. You know, you talk about, and we've talked about over the course of these webinars, the balancing act, understanding the constitutional obligations, understanding the applicable laws and case law, and then crafting those policies so that they're consistent. And then there's this next part, and it might even be the subject of a different conversation a little bit more in depth later. But we have a situation where, holding folks accountable, especially for unaccompanied minors, it can be tricky in communities where the services that staff would reach out to for, helping with the safety concerns, or, just a situation where a child shouldn't be by themselves, or in using the library inconsistent with the policies. So what kind of thoughts or ideas do you have about making those policies realistic and fitting kind of the constraints of the community as well?
Right. It's a good question, and one that as I mentioned, it's going to depend community to community on what is available. And I think back to my youth in Sydney, and there were probably times that I was out of control in the library when I got to come to town to go visit, and who would they have called? Would they have called the sheriff? Would they have called the police department, or was there someone else that they could have called that would have been able to redirect or hold until they found my parents? Not that my parents dropped me off and left, but you think about those things, and in communities may not have as many services. There may be just the sheriff. It may be that the sheriff is 40 miles away and there is no one else that's available. There may be the situations where there is simply no other social services within an hour distance away and driving. So what do we do in those situations? The first thing is to always remember the obligation to preserve a safe and appropriate setting. And that's not to confine the student to a particular room. It's not to hold the student in a particular area, but student and child to make sure that they are safe, contained within the library area, the library space. And if it's possible to have, this may even be difficult if you have a staff of one and maybe half-time volunteer, to have someone who can sit with that child until you find out what's going on. That may be unlikely as well. Hopefully in those situations, and this is just a reliance on the Montana way of operating, if you don't know where the parents are, you might know where grandma and auntie is, and you can try and find them in that way. And that's not a formal a way to approach things, but it is often how it's going to occur. But again, back to the best practice of keeping someone safe, keeping that child from leaving the facility without accompaniment, walking that line between caring for them and supervising them versus preserving the library, the order of the library, and the appropriate way to do that. So that's going to require then those circumstances within the community to be taken into account. What do we do? Well, we don't know where the parent is. We're going to keep the child at the library as best we can until such time that we have the knowledge as to where the parents are. That does not include any care for it until it arrives at a situation where there is an emergency. And if that emergency does come up, then getting the first responders to start traveling to the library, if it's a more isolated area, is a way forward. And if there is a way for the library to know or monitor and identify who the guardian or the caregiver is that dropped the student off or dropped the child off, if you have the ability to review the surveillance, if you have the surveillance capabilities, as we talked about, finding out who dropped them off, and you're able to identify that person there. Do we know who that is? Do they have a card with us? Do we have a phone number for them? Utilizing the tools at your disposal while keeping the child safe is the way to handle it. At some point, someone has to retrieve the child. If they do not, then we have a bigger concern that the child has been left accompanied. That can trigger all sorts of child neglect or other obligations that you would consult with the local authorities on how to handle. But primary goal would be to keep the library in order, keep it functioning, but keep that individual who doesn't have the capacity to leave on their own accord safe until such time as either the authorities can arrive or the parent or guardian can be identified. So how you write that into a policy, how you write that into an operational procedure is a different discussion, but everything can be written down. And if you write it in a way, as we've always tried to do as we handle these things, you don't try to anticipate every possible scenario. You write it in a way that is flexible enough to apply it to anticipated scenarios while always giving yourself a fallback to let the director or the staff make a decision in real time that's supported by the board through its policy and consistent with the law.
I think that's really, really helpful, Kris. There is that reality. We do have another question, and it is about liability. So, if do libraries open themselves up to any liability or legal issues if they ask a child, let's say a 12-year-old, to leave the library due to disruptive patron behavior per the library policy? So what if when the child is warned about their behavior, they just leave of their own accord? So there's a couple things going on there. Consistency with the policy, staff following through and saying you need to leave because you're being disruptive. Are there issues around liability that you can think of with that question?
There can be, and you think about middle of January and a student shows up. These kids don't wear coats anymore or boots or anything. They're showing up. They have to wear shorts all the time in their Crocs, and so they're in the library in the middle of January, and they get excused from the library for violating the behavior policy, and you turn them loose at 5 o'clock when it's pitch black outside and it's winter time. There is a possibility that the district or that the library district or the public library is um, uh, have some exposure there. And that's something to take into account coming back again to the circumstances, how we manage those students who are deemed to be um, minors, but not necessarily children under our policy as you have it put together. Does that student who is excused from the library and left on their own accord, you don't have an obligation to transport them, but there is the possibility of exposure there for an injury to the student if they are told to leave library property. So a way to handle that is taking into account the possibility of the conditions outside. If they have a phone on them, which they mostly do now, tell them to call your parents or call someone. We want to make sure you're safe, but you can't be in the library the rest of the day. Or what's their name? And if they give you a name and you're able to contact the parents or work with them on how to contact the parents so that you know they have a ride, then getting them in that situation. So taking that a step further, even if it's not wintertime, if someone is told to leave the library and they don't have transportation, you're not obligated to transport them. But if they were to be injured by a moving vehicle walking home or some other type of harm comes to them, where does that stop? And where does the library's obligation start and stop when it comes to that type of transportation? And the library is not serving in the absence of the parent. It's not serving in the capacity of a parent while the child is at the library in a way that a school would be, for example. And this obligation of a school goes while they're transported and walking to and from the school. That's the case in a library. So it's a situation where you have to calculate the potential harm, the anticipated injury that could come based on the circumstances and conditions versus the student simply being capable of getting themselves home without getting hit by a car, so to speak. And so that's it's the situation where you're always thinking about the the possibility of litigation, the possibility of injury, but you don't let that dictate how you run the library. You let it inform you to make sure you make the right decision. You're not going to prevent anyone from bringing suit against the library. You're trying to put yourself in the best position to defend against that suit. And that means taking into account all of the different factors that might exist and be different from January to August or ages 15 to 17 or 12 to 14. All of that takes into a place, and your staff are trained and regularly trained to know how to respond to those situations to keep the patrons safe, but also to make sure the library runs effectively.
There is an additional kind of nuance around unlawful confinement, and I would say this might be one of those special circumstances or specific cases where your county attorney or city attorney might be consulted if there is that just wanting to understand if there is any liability or exposure of the library to potential legal action.
It's a great point, and it comes back to ensuring that the student knows their rights, the child knows their rights. You've just sat with me, your parents know you're here. If you leave, that's a decision you're going to have to deal with your parents. And it's a matter that you're going to have to deal with at home. I can't keep you here. I'm not requiring you to stay here, but for your own safety and for the agreement that we just reached with your parents on the phone, you need to stay here until they come get you, or someone that's been designated to come get you does. That leads to all sorts of questions that we could talk about for another hour, which is who's the responsible adult in a situation where the teenager is getting into a car with another teenager who the parents may not want them associating with or not riding around with. That comes back to all sorts of factors that blurs the line where the librarian is serving in the capacity of the parent. That's not the librarian's role. So keep all of that in mind. You're not confining anyone. You're not forcing anyone to stay where they don't want to be. But if there is a tacit agreement reached with the parent that they're on their way to get the student because it's 40 below, then the student tries to leave. That's up to them. But hopefully everyone has enough common sense to say, I'm going to wait for my ride to get here.
So many nuances. Kris, I want to thank you so much for your time again today. We have, 2 additional topics that we're going to cover towards the end of September. Just to let everybody know that we'll have our recording and a summary and resources for this session today available in the Aspen event. Enough everybody for sharing some of your ideas and policy language in the chat that will become part of the summary for today's meeting. So thanks so much, everybody. We appreciate your time and everything that you're doing on behalf of your communities and in your public libraries.
Thank you. See you all soon. Please send us an email if you have any questions.